Well, good morning, today being the 9th of February, and we are continuing with the evidence in chief of Judge Makhubele. And I just have to remind Judge, you are still under oath, Judge, and you may continue with your evidence.
Thank you, President and honorable members of the Tribunal. I indicated that today I'm going to touch on the evidence of Mr. Mukhasho and required a bit of time to read his oral evidence, which I just had a challenge with regard to the documents that he handed in during his testimony. As you recall, I was being represented and the documents were accepted by both counsel and my then attorneys of record. So as I go along and get to those documents, I will indicate which ones and request to have copies and consider them. Thank you. As testified by him, that's Mukhasho, I confirm that we've known each other from the days when I was practicing as counsel, and he has briefed me on several occasions. With regard to our encounter at Prasa, or rather before I go there, he is one of the people that called me to congratulate me on my appointment as part of the interim board of Prasa. At the time, we didn't speak much, he just congratulated me. And I did not know that he was doing any work for Prasa or in the Prasa legal panel, or particularly that he was an attorney of record in this particular matter or matters that we are dealing with. After I sent that memorandum of 28 November to the then acting group executive, Mr. Zide, and it has already been testified that it ended up with him, and I received reports from him, and I was surprised because the matter at that stage was supposed to be still an internal matter, but nevertheless, I consider these various reports that have already been handed up on record. The meetings that I recall having with him were on 14 and 15 December of 2015, because I have a diary that I can still refer to.
I'm sorry, just repeat the date. What date did you meet him, you say?
14 and 15 December.
2017?
Yes.
Thank you.
If there are any other prior meetings, it could have been, you could have met with the then acting CEO, because what I remember, there were meetings that were arranged with the employees that are mentioned in the report of the commissioner. I could have attended some of the meetings, but all those people that are mentioned in the insolvency report had meetings with the acting group CEO, except for those who were no longer with PRASA. I'll get to them. That would be Montana, and the other one that I remember is Vermeulen, and another one that's mentioned is Bupape. At the time, they were no longer at PRASA, and they were not requested or required to give any input on anything. With regard to, I will deal with his allegations pertaining what's in his report when I comment on his evidence. But I wish to state right from the outset that there was nothing secret about what was happening. An example that I will give is there was an involvement of the internal auditor with regard to one of the cases that, one of the claims. If you read the report, there's one claim that pertains to a memorandum that was drafted by one Pungula. Yes, I must add his name too. This Pungula was no longer with PRASA. That memorandum is in relation to one of the claims, and that's the claim that was not settled after my intervention. So not all claims, we all know by now that not all claims were settled, so this is one of them. The internal auditor, Mr. Rashik, you might have seen some of his reports on various matters that the board was dealing with, was requested to do some inquiries with regard to that particular matter. And he was not able to, I'm going through this because some of the things Mr. Botes would not have known, and he doesn't know, he didn't testify about them. But Mr. Mukhashwa certainly knew. I will refer to, according to the report of the commissioner, the claim was about an extension of a contract, a contractor that has done work without formal approval of an extension. In that memorandum, this Mr. Pungula had requested the then CEO, Mr. Montana, to regularize the situation because work was performed before a formal extension. If you read that memorandum, which I believe is part of the record, you will see that Mr. Montana had given a conditional approval, which was subject to certain conditions the officials involved in that extension would have had to be identified and be requested to provide reasons. So this is what the auditor was required to make a follow-up on as to what happened. And he did not find anything because no one was prepared to cooperate. And at the end, after this particular matter was not settled, I sent an email to, I will give you a copy of this email. It's dated 18 December 2017. I'm responding to Mr. Rashid Zaman and directed to Lindikaya Zide, and I copy Mr. Zaman. I won't read everything in the email, but just the relevant part with regard to what I'm talking about. My recollection, I'm reading the email. We all know from contents of that memo that acceptable procurement procedures were not followed. Reasons were given. Authority was sought to regularize the work done. We already know that the former GCEO approved, subject to reasons being given by responsible officials why the contractor was allowed to do extra work before authorization. We cannot undo the authorization by the former GCEO unless you want to tell me that he had no authority to deal with the memo in the manner that he did. What should be followed up for purposes of our exercise and report is the process after his conditional approval. My understanding is that he wanted to authorize the payment, which naturally must be explained. It also means that he will then extend the scope of the contract in line with the acceptable procurement procedures. As we discussed, the scenario is different from where PRASA would have already lost money by paying a contractor who did extra work before authorization, only to discover later that it shouldn't have. So the issues to be addressed from our discussions are, in my view, as follows. One, whether responsible officials, as indicated in the conditional approval, were identified. If so, who are they? Did they give reasons why disciplinary steps shouldn't be taken against them? If not, why? If they did, what was the outcome? Two, whether 14 million that's referred to as contract value includes the initial contract amount of 5.6 million. Three, verify the correctness of the contents of this memo, i.e. that the memo is not a fabrication from the contractor, but real issues that happened. Four, verify that work was done as per that memo. Someone must attest to this. Five, reasonableness of the amounts claimed. It's not sufficient to simply say you propose a certain amount. What's the basis? Who conducted that exercise? 5.1. I think this will be the last part, and it will involve the contractor. We must answer 1 to 4 first. Way forward. Let's wait for CIA to come back on this contract. PRASA attorney, Mr. Mukhashwa, has indicated that we can engage him too, as he has some information that may assist. I guess it's what he was given by the same employees. I think internal audit may leave it for now until we get a report from the attorneys after CIA has clarified certain issues. That's as far as I want to read this email. So what I'm saying is the evidence of Mr. Mukhashwa, in essence, is that when he attended meetings or came to PRASA, he had no inputs on anything. He was simply given instructions to to settle and letters directed at him. And this is what I'm submitting as proof that he was part of the discussions on the merits. And this is the reason why that, that claim, if you look at the summons and also the report of the commissioner, there was one claim for 14 odd millions, where the contract, the initial contract was 5.6 million, and there had been an extension which was not authorized. So after doing all this exercise, then my, and our discussions, it was agreed that this should not be settled, and I believe it went to arbitration. You will recall that he also confirmed that not all claims were settled. There are some that, I think it's specifically this one that proceeded to arbitration. So that's, when I give my testimony about Mr. Mukhashwa, he's not someone who just came, was told PRASA is settling, he received a letter, and then he transmit to CIA attorneys. He's someone that was involved, that was prepared to give information, and he did give on the ones that were settled, and this one, he undertook that he was going to assist because he had information. By then, he had already consulted with the responsible officials, as he has testified. The consultation was after the liquidation, or rather the insolvency inquiry. So this is my starting point, President and honorable members, that when we talk about him, he was not a passive person that just came to get instructions and left. Let me get back to my first encounter with him. A meeting was arranged with him to come and discuss what was in his report. He had already responded to the memorandum, although it was supposed to have been internal lawyers, but he had already responded to those memorandums, or his reports are already on record. As I indicated, the meetings, I don't know why internal legal team did not attend. Safe to say, I was assured that they are aware and that they have given excuses. I've looked at his evidence, and I'll get to the relevant parts specifically with regard to the allegation that he was barred to speak with the legal unit. Before I even point you or take you to the relevant parts of his evidence, I don't think that's what he said. I think at some point, he said, I want to make a distinction between being told not to deal with and being told not to speak to. And his evidence is that he was told the matter is being handled by the board at this stage, and you will be dealing with the board through Mr. Zide. So how Mr. Dingiswayo and Ms. Ngoye interpret it, or how the tribunal will finally interpret it, depends on the context. But I don't think I've looked at his evidence, he doesn't use the word bad. He simply said, I was told you will deal with through the CEO, because Zide then was the CEO in an acting capacity. I move to the next issue. So after he came for the first time and we discussed his memorandum, he was in agreement, having been given information from the consultations that the CEO had with the various employees, and based on the information that he had already collected from his consultation with with the same employees, that the claims should be settled. With regard to the actual date when the claims were settled, I recall in the meeting it was him again, Mr. Zide, the acting CEO, myself, and we were expecting the legal team. And an excuse came again from the CEO that I think this is the day that they said they would not attend because there's an office party. And another thing that I want to mention about that particular day, because this impacts on the documents that, or some documents, or a document that was found to be in possession of Mr. Botes. On that day, a decision had already been taken. It was a question of sitting down with him. I'm talking about the attorney and the CEO to look at each and every claim, what it's all about, the amounts and the offers that should be made. Mr. Botes was invited to that meeting. He unfortunately could not attend. He said, because we waited for him, he said he was going to come in the afternoon, but unfortunately he did not come. He called in the afternoon to say he was attending to an urgent matter at Bloemfontein, if my memory serves me well. And his request was that, can he please be copied on the letter that will be sent to the formal attorneys. So that was the request, and the request was acceded to. The other thing that I need to mention, we've had evidence that the owner of this company, how corruption and everything, but the fact is, even from this set of claims, from these very summonses, a claim was settled by before my time, by the legal unit. I think this emerged, Mr. Mukhashwa informed us about it on that very same day, and I think it also appears from his evidence somewhere. I think it must have been at the commission. So when you tick, there's that claim from these summonses that was settled before my time. There's this one that was settled, and I think those that were settled have been indicated. And the other thing that you should take into account is that I don't know what the issues are or were between Mr. Dingiswayo and Mr. Mabunda. But as Mr. Botes has testified and as the record shows, this was no longer a Mabunda matter. This was a matter that was being pursued by the liquidators. We've already had evidence from, that's why there was that insolvency inquiry. If I can, I just want to start by referring to his own evidence, having cleared that issue that Mukhashwa was not a passive person that came to collect a settlement instruction. And whilst I'm there, I have noted, President, all the witnesses that have been called, well, except for Mr. Botes, Ms. Ngoye, Mr. Dingiswayo, Mr. Mukhashwa, they all testified that they were seeing the transcript for the first time here in these proceedings. And the report, they have not had an opportunity to go through it, obviously, because they all claim that they had not or have not seen it before. And then my predicament then would be, how did they lay a complaint that there were no concessions, major or minor or simple concession, if they have not had sight of the report? For whatever reason, whether they were denied the report, but the record, the JCC record, I attached that report, both the transcript, the insolvency inquiry happened over a period of, I think, 2 days, and then there's that summary by the commissioner. If at the time they laid this complaint, they had not had sight of it, there was an opportunity after I had made it available to the JCC for the witnesses to have a look at it and still consider and still make up their mind whether there are concessions or not. But I would understand that they are not the complainants. The complainant is Unite Behind. So I haven't had evidence from Unite Behind how they came to the conclusion that there are no, actually the JCC proceedings indicate that from the report of the JCC, it's that this does not exist. The report itself doesn't exist. But it was toned down to non-existent I don't want to, it just escaped my mind, but the point I'm making is, this is the complaint of Unite Behind, hashtag Unite Behind. I don't know how they came to, we haven't heard them whether they had seen these reports or transcripts or anything, because they are the ones who are making allegations about the non-existent of the report, non-existent of the concessions. But the witnesses, PRASA witnesses, up to today, they say they have not seen this report. So I don't know how you will deal with it, because I can only argue with someone who has read the report. And if, I don't know if your mandate is to read this report and then agree with me that there are concessions, because from the witnesses, there's nothing that they can help you with because they have not seen this report. I'm not sure if, before I accuse Unite Behind, as I said, we'll get to what actually their complaint is. Because as I said, some of the things that the JCC has referred to the tribunal do not come from Unite Behind, from the complainant. So even in this one, we'll have to look at actually what is the complaint, because things like I terminated the mandate of PRASA attorney and appointed my own attorneys, it's not in the complaint. So I don't know who the complainant is, and when I appeared before the JCC, there was nothing of the sort. So even in this one, before I accuse Unite Behind, we'll have to look at what the complaint is all about. Can I now go to the evidence of Mr. Mukhashwa, if you allow me? I think that's it. Pardon me, I'm looking for his evidence, my notes that I've made. I seem to be. Let's try and find it. I don't know whether it's in this book. It's not this one. This one. Thank you for the indulgence. I got my bearings. There's evidence here before you that even before I joined PRASA, Mr. Botes or Advocate Botes had already approached Mr. Mukhasha with regard to settlement because of what the evidence that was led at the insolvency inquiry. That's the email of 6 September 2017 that Mr. Mukhasha said he responded, and he, on his second day of appearance here, he handed up certain documents, which is what I want to request from Ms. Harrison, Advocate Harrison. The documents that Mr. Mukhasha presented during his testimony include this particular response as well as some reports.
Can we just get clarity? What document is it that you are looking for, Judge Makhubele?
Let me just list them. It's the reports that he said during his testimony he submitted to Mr. Dingiswayo, and also a letter that he says was his response to Mr. Botes.
Can we take it one at a time? You say this is a report submitted
To Mr. Dingiswayo.
to Mr. Dingus. Why are you looking for that?
Yes.
Anything else?
The specific dates of these letters. There's a letter of 6 September 2017. There's one that is addressed to Mabunda. The second one is dated 8 September 2017, addressed to Matopo. And the third one is 8 September 2017, addressed to Mabunda again. And he spoke about the reports that he gave to Mr. Dingiswayo. So as I respond to his evidence, I will just reiterate what I don't have. They are with my previous attorneys.
May I suggest you inform your attorney what reports and memorandum, if anything, that was submitted to, amongst others, Mr. Dingiswayo, Mr. Mavunla, Mr. Matopo, are there any other reports that you are looking for?
No, this is, when I read his evidence, as he was testifying, he handed up these documents.
Yes, no, I just want to know you don't have it and you would like to have a look at it.
Yes.
Is that correct? Anything else? Because what I'm going to do, I'm going to adjourn and refer your request to the evidence leader and to the OCJ to see if we can find these documents that you are looking for.
That's it, President. It's 3 letters and reports that he submitted to Dingiswayo.
Yes.
According to his, if that's all.
Yeah, I will then stand down for 10 minutes and see if we can find these reports you want to refer to.
Thank you.
Is there anything else?
That's all
Yes.
for now. Thank you, President.
Thank you. Advocate Harrison, you understood what Judge Makhubele is looking for. See if it can be found anyway.
Yes, yes, Chairperson.
If it's been handed in, it should all be part of the transcript and the volumes. Let's see if we can assist her and get these documents she's looking for. We will then stand down for 10 minutes.
Mapapila, like, loko munhu akatestifya ku ni na papila leri na papila.
Yes, thank you. Do you have the documents you were looking for, Judge Makhubele?
Yes, I have the 3 letters and the reports. They are actually reports that came to my attention in November as it's common cause. But because I haven't seen them for some time, I'll just see what was said about them. But the letters, I have them in my possession. I can proceed now.
Yes, please do.
I wish to correct something. I said I met him 14 and 15. It's actually 4 December, and the last day, that's when the claims were settled, which is 14 December. So it's 4 and 14 December. On the report, President, that he submitted subsequent to my memo, there was I can call it a controversy here, whether he addressed prospects of success or not. And my team, legal team, took him through the reports, and the argument that we are still going to make is that prospects of success were not addressed, because it's common cause that when he filed the pleas, he had not consulted with the relevant officials. And for me, for anyone to start talking about prospects of success, you need to know the version of your client, not the legal team, but the officials. That's when you can say, not necessarily that you must plead that, because you can only plead after you have obtained full instructions. But we all know that at this time, he had not yet consulted with any of the officials that were doing the work that would have been covered by the summons that formed part of the claims. His consultation with these officials only happened after the insolvency inquiry, and that was for purposes of collating information as they were directed by the commissioner. The next thing I want to address is he says our meeting was on 15 December, but I seem to have, our last meeting, he says, was 15 December, but I seem to have recorded 14 December. But the date would clearly appear from the date the offers for settlement were made. According to my notes here, it's 14 December. No, actually it's 15 December, yes, it's correct, it's 15 December. And when asked what was discussed.
Sorry, let's just get clarity on that.
Yes, I confirm it's 15.
It's the 15th of December, that's
Yes,
the date.
not 14.
Yes,
Yes,
just to get clarity, it was the date that settlement was discussed.
yes.
Thank you.
the last day. Mukhasha was asked whether there were discussions, what was discussed in this meeting of 15 December, and his response is that Makhubele, meaning me, simply told him that I had considered the options and decided to settle. I wish to deny this in the strongest possible terms, President. As I said, this is the meeting where we sat and extensively went through each and every claim, whether this one should be settled or not, and which one should not be settled, and what has already been settled. And I can just take you through what according to me, was discussed on this day. The first claim is case number 74281 of 2015. This is the one concerning the memorandum of that was drafted by Pungula, where they were seeking regularization of extension of the contractor having performed extra work without formal extension. This is the one that I was talking about. And at the end of our discussions, this is where it was the contract for material coding and data cleansing. This is where, according to my recollection, assisted by my notes, of course, there was no mandate to settle given to Mukhasha, and because we were awaiting confirmation whether the 14 million included the 5.6 million that was the initial contract. And as I've already indicated in my opening address, these are issues that were referred to the internal auditor post this meeting between me, Mukhasha, and not post, but as a follow-up that he needs to follow up because he had already started with the investigations. And the email that I've read into the record, it was after our meeting with Mukhasha, where I was telling the auditor that he must liaise with the attorney. The attorney, it's common cause, is Mukhasha, because he said he has some information to assist in further investigations. So there was no mandate to settle in that case. And number two, I'll get to the rail solution claim, because you will remember all but one claim was for, there's one claim that was not part of the company that was in liquidation. That's the claim that was for rail solutions, but it was settled. I will give you the circumstances. I will move to case number 77333 of 2015. Tech assistance for support of the National Signaling Project, stage phase 1 to 5. The claim was for whether this is millions or, but here, from my record, it appears to be that one that was settled, because here the indication is concession amount was paid. I think there was also evidence about a claim that was settled, but the only remaining issue was costs. So I believe this is the one. And the next one is case number 73934 of 2015, rehabilitation of infrastructure. The amount there's something wrong with what I've written. It can't be 7 billion. I'll have to refer to the summons, but this was settled. And then there was the next one, case 73933 of 2015. The amount here is 8,095,950 rand. This was settled. The last one is case 47598 of 2016. Depot modernization, Salt River. The total is 15,371,739 rands and 87 cents was settled. I mentioned there was yes, they were divided into two. This is the one of CIR rail solution that I indicated was not part of the company in liquidation, but was settled. I think the legal team made some what can I say? They are saying this one, if at all it was about the company in liquidation, this one does not form part of that. This is case number 47597 of 2016. Technical advisory for the new digital railway signaling network. The claim is for an amount of, again, I've written many figures here, I'll have to confirm, but I think the settled amount is 19,583,778 rands and 42 cents. So as I indicated, President and members of the tribunal, some of the persons that testified at the commission were involved in these matters, in these claims, and some that still had to go and testify were involved and some were not involved. And I've already indicated that the CEO had started consultation with the people that testified at the insolvency inquiry, which consultations I was allowed to attend. I can give you the names of the persons and the dates on which I don't know if the same people, but in her evidence, Ms. Ngoye says she called some of the people. She didn't consult with them physically, but as she was preparing for the High Court application, she telephoned the employees. She didn't mention them by name. I could be mistaken, or it's in the affidavit, but the CEO in which consultation I was allowed to sit in, Mr. Kobue. I don't know whether it's Kobue with K-O-B-U-W-E or K-O-B-O, but there's a Mr. Kobue. There's Mr. Baltek. We have seen his report. The others didn't submit reports, but they gave oral submissions. There's Mr. Thabo Mashia. This over different dates. This Kobue was on 4 December 2017, and Baltek is the same day, 4 December. 5 December, Thabo Mashia. He had not yet testified. He did not go to testify, but he's one of the people that received a subpoena. There's also one person called Litsane Ratava. This, he had not yet testified. He was still going to testify. In the High Court matter, Ms. Ngoye alleges that all these employees, they apparently agree or acknowledge or concede that they had consultations with the CEO and me, and that they gave certain information, but apparently they were intimidated.
You saying?
That's the allegation that.
Yes, just repeat what the allegation is.
The allegation is that these people were intimidated to give the information that they gave that culminated in the settlement. But I don't know who specifically says they were intimidated and who intimidated them. But you have seen the report of the commissioner and the inquiry itself. There was a public session, and the report is in writing. They testified under oath, and what they told the CEO in the consultations that I attended, I'm not aware of any intimidation, and no one has, up to now. This is 2017, now we are in 2024. No one has ever filed any complaint of any intimidation or having been coerced to say anything, but surprisingly, what they said is the same thing that they said in the inquiry. When I read the letters that were provided to me, it appears some of the issues, there was some attempt by Mukhashwa after the insolvency inquiry to investigate the claims further. So, and you will recall that at some point he was given an instruction by, he says it's Dingiswayo, that Baltec should not cooperate with the commissioner. And Dingiswayo, of course, says he doesn't know where that instruction came from. The report of Baltec, you have it in the record already. So all these things, President and honorable members of Tribunal, all this information coming from the various consultations, this is what was discussed when the claims were finally settled and there were other one not settled. So I deny the allegation that particularly by Mr. Mukhashwa, that when he came, he was just told to settle these claims. There was a comprehensive investigation and collection of information from the employees, which culminated in the settlement. You will recall in one of the annexures, the memorandum from the acting CEO, the last one CEO, Mr. Mulepo, to Ms. Ngoye. She was requested to, this was in response to her affidavit in the High Court, that the employees deny that they made, it's like they testified under oath, and if there's any information that they gave it under duress. And the CEO asked Ms. Ngoye to give the board reports from these particular employees. That's the letter directed to her. It's in the record. I cannot recall the date. I do not know whether Ms. Ngoye did anything about that report. But as far as I know, there's no employee who was intimidated to give anything. So those are the circumstances under which these claims were settled. So I'm disputing what Mukhashwa says, that when he came, he was just told, settle. Here's a mandate. He says he was taken through cases to settle and the amounts. I deny that. As I say, there were extensive discussions and the CEO had made extensive consultations. And his input, as I said, he said he had information with regard to the rail solution matter, that it warranted it to be settled, and also the that other matter, the Pungula memorandum, that he has information that may assist with the further investigations. That's why it was not settled. And Mr. Mukashwar was reluctant to comment or answer a question as to whether the witnesses in their testimony before the commissioner made any concession, and his answer is simply that he can't respond because he wasn't really involved and he has not read the transcript and the report. This is an instructing attorney talking in 2024 on the report that was issued in 2017. In his report that have already been handed up, the documents that I was asked to, that I asked to look at and also to read, I had just a quick glance. Somewhere in his report, he is saying he doesn't have those transcripts of the report. And he wants to see them. This is 2017. I mean, what prevented him between 2017 and 2024 to read this report so he can come and assist the tribunal? So I am saying, I don't want to cast any aspersions on anyone, but this excuse that these witnesses have not read this report, I don't think it's an excuse that you should accept, because they knew what they are coming here for. As far back as 2019, when the complaint against me was filed, that one of the issues is that there are some concessions in the report compiled by the Insolvency Commission, and all they needed to do was to read that report, and up to date they have not read it. So that can be an excuse that must be used against me, President, because I say there are concessions. The next thing, he says I gave him the amount to settle. I mean, the amounts are in the, sometimes, somewhere, the amounts in the summons are higher than the claims were settled for. And the reason being that when you read the transcript, more social where there are concessions, they will say they've claimed this amount, but according to me, I will give an example of Balte. He was asked to go and check, and I think the amount that he came back with was lower than what was in the summons. So I dispute that. I sucked these amounts from my thumb. And he was asked if he noted the amount, and down he says he must have scribbled down, but he hasn't come back to tell us, to tell this tribunal what those amounts are according to his notes. I also deny that the settlement was not discussed with him, because that was the purpose of the last meeting, where I say we all sat down and the CEO presented the outcome of the investigations and consultations that he has been making with all the witnesses. And he was sitting there, he was making inputs, particularly with regard to the two claims that I'm talking about. And as to whether he engaged with Dingiswayo after 15 December, he could not recall. But he remembered Dingiswayo calling him. And the controversial issue of whether he was barred or not from talking to Dingiswayo, I think he clarifies it here in this, when he answered this question. He says, in this meeting, that's 15 December, that's where he was told that the CIA matters will be dealt with by board. And he shouldn't communicate with legal, but somewhere else under cross-examination, he makes a distinction. He says he was only told that the board will deal with it through Mr. Zide, who was the CEO at the time. Yes, immediately, President, you followed up on that question and you asked him whether he was told not to talk to anyone from legal department, and his response, that's where he is now not certain. He says, I'm not sure whether I must draw distinction between deal or talking with legal. I was told he was told not to deal with legal with regard to their specific matters. And his understanding was that he must not communicate with legal. He could not recall whether he called him Dingiswayo or not. That's his understanding or his interpretation, but what he was told was that these matters are being dealt with by the board, not that he was told not to. And the issue of interest, this was taken up with him by my representative, and he considered that the instructions given to him was to include interest. And he's the one who made an error, not to include interest. This is not now common cause. There's an email that was presented to him from me to him, copying Zide. It's in page 33. I didn't write which volume, but it's a popular email. We should all recall it because how it's presented is that in that email I gave Zide an instruction to pay Siaya, if you recall, President and members of the tribunal. And I think, as usual, media ran with that narrative. The headlines were Makhubele instructed Zide to pay Siaya. This is the email. I wish I can find it, but my recollection of how it reads is that this is after they had finalized the issue of making the offer and revising and including the interest, and I think I was advised by email that everything has been done, and my response was, I think the email that I was responding to was from Muhashwa, because my reply was directed to him and Zide was simply copied. My response, if I recall, was to say attend to payment. We all know that Zide was not in finance. He was the CEO. And if after the process, it's ongoing, if there's going to be any payment, he will have to take whatever document and make whatever submissions he makes in terms of payment procedures, and finally it will be the finance that effect payment. So I didn't say pay, I said payment, attend to, and that means he knows the process. He will attend to whatever is required to get to the stage where the person that pays, we all know it's the CFO. I never instructed the CFO to make, or the finance department to make a payment or anything like that. I cannot comment on what happened when well, it's common cause, that was the end of his involvement, and CFO did not pay. Then there was an application to make the settlement arbitration orders before Judge Brand. I had nothing to do with that. I did not go, they went there. And after they had obtained arbitration orders, then there was that application to make arbitration orders of court, arbitration awards, I apologize, to make them orders of court. And I see here he says he requested instructions and no instructions came. Yes, no instructions came because at this time there was already the finance department had already refused to pay, apparently on advice, because that's how I understand it. They get advice from the user department. The user department in this case would have legal. And then the legal advised them not to pay. And she did not pay. At this time, if you follow my conversations with Botes by our email and WhatsApp communications, which are on record. Beginning of 2018, after I heard that Ms. Page, that's the CFO, was refusing to pay, I informed Borders because he kept on inquiring. I said to him, I'm no longer involved. There is this rumor going around that the settlement were concluded unlawfully, and as such, there will not be a payment. I don't want to please contact the CEO. And the new CEO, who is Mr. Mulepo, I gave him his number and he followed up with him at the time. So I was not involved in the application to make the arbitration awards orders of court. And the next thing he testifies about that I want to deal with, he says he struggled to get instructions. Yes, I don't know who he was asking instructions from. He confirms my version that I did not terminate anyone's instruction, any attorney's instruction, and in his evidence that this happened in the meeting that he testified about, where he was called by, it was Zide, Ngoye, Mulepo, and Dingiswayo. This is the meeting where he was confronted, and at the end of that meeting, he withdrew. They didn't terminate, but he realized his conflict, that because he was dealing, is the person that was involved in the settlement, he cannot now oppose the application to make arbitration orders, awards orders of court. And members of the tribunal, the picture that Mohashwa paints of that meeting is that he didn't hear any other person talking except for Ms. Ngoye. She's the one that was talking, giving everyone instructions and making allegations that I did not have authority. And we also had that the person that I'm saying had authority, Mr. Zide, was apparently in that meeting, but according to Mohashwa, when Ms. Ngoye made all those allegations, no one spoke, actually. It's only Ms. Ngoye that spoke. And my comment there is, I've already said this, that the kind of authority that she says she had at PRASA, in the same letter that the CEO wrote to her, he requested her to provide the board with her written, actually he was telling her that he has requested the HR department to provide the board with her written contract and also her delegation of authority. By the time I left, she had not yet presented this. And I have seen, or I've heard her being led in evidence in chief about her contract. If my memory serves me well, she has submitted a contract that she signed at Intersite. Intersite is one of the subsidiaries of PRASA, where she started, and also a transfer that was approved by the board. And I think a question was also put to her whether she has a written contract with regard to her current position, and at the risk of making an error that I'm prepared to concede if I'm making a mistake, I think her answer is she doesn't have it. And she hasn't provided you with any, she hasn't provided you with her delegation of authority, financial delegation, because we know there's financial delegation in terms of...
Sorry, Judge Makhubele, you're now talking about events that occurred after you left on the, I think, the 18th of March, 2018.
Oh, pardon me, I didn't hear. I thought you were asking me, you wanted to ask a question. So you're asking me about what happened after I left?
Asking the evidence you've been giving the last 5-10 minutes, are those not events that occurred after you had left PRASA on the 18th of March, 2018?
No, Judge Mushidi, there's the requests to Ms. Ngoye were formulated when I was still at PRASA. I think I make that point somewhere in my papers, that in the last board meeting that I chaired, because we were preparing for the report to go to the minister. That's the day when the board wanted to have sight of all these things. So all I'm saying is, I don't know if she gave the board that after I left, but it was requested before I left. But the request to her would have been obviously by correspondence after my departure. Because I chaired this last meeting on the day that I resigned. So what I'm saying is, I don't know if the board followed through. Thank you.
Thank you.
I was still talking about the meeting where this Mukhashwa withdrew, and he confirmed that he had instructions to proceed with arbitration. And I believe this is on the one matter that was not settled. So he was not terminated. He's still proceeded to represent PRASA. Just want to go through if there's anything under cross-examination that I need to just clarify. And President and members of the tribunal, there is confirmation from Mukhashwa that the settlement was not secret, and this morning I also read an email that from an email trail between me and the internal auditor. If this was secret, I've already said, one would not have made all these efforts, all these, the CEO engaging in all these investigations and me leaving all this paper trail. I don't think that's how it was known. It's only that because they are not happy for whatever reason that they label it secret. Then the other thing that I need to also comment on, he was asked about the fact that the AG, Auditor General, mentions the Mukhashwa firm in the report. It's mentioned in the AG's report. And when the AG deal with the panel that was not properly constituted, in particular with regard to the bill, the legal bill. In the AG's report, Mukhashwa is second after Werksmans in terms of money paid to the firm. It's only it's number 2 after Werksmans. And this was because one of the requests, I think, to the legal team was at the time when we were dealing with the legal bill, the amounts that had already been spent on this matter, to defend this matter. Pardon me, I'm just going through to see if I'm leaving anything. The emails that I requested and that I was provided with was with regard to whether he has replied to the email of Advocate Botes, and which he claimed to have only seen that morning when he was testifying. So I think he had to rethink and ask his office if he has responded to it, and according to him, he has responded. But my legal team, when asking him questions, they made a point that he was not responding to the specific email, and I think I will also leave that for argument.
Is there anything further you wish to draw to the tribunal's attention, Judge Makhubele?
Yes, President, I'm sorry you didn't hear me. I was saying, just give me a moment to see if I'm not leaving anything.
Yes, we'll give you a moment. You may go through your notes and let us know when you're ready to proceed, if you have anything further.
Yes.
Thank you.
Thank you. President, I think I've dealt with what I needed to deal with in his evidence before this tribunal. What I have not addressed is what I'm satisfied that my legal team have dealt with extensively, and that will be matters for argument. So I think I'm done with the evidence of Mr. Mukhashwa.
Yes, is there anything further then that you wish to say?
Yes,
In
President. There's a few things that I wish to say in as far as this may not have been covered by the evidence of the witnesses. So there is, and if you can allow me a chance to deal with those issues. These are issues that are in the complaint itself.
Well, what do you wish to do? Have you found what it is you're looking for so we can continue, or what would you like me to do?
I would like a bit of time.
Oh, you want me to stand down for how long?
This is 20 minutes, 24. For 20 minutes, just for me to, 20 minutes. 20
So,
minutes.
20 minutes?
Yes.
Well, what we'll do, we will stand down for lunch, and we will all meet back here at 1:30. Would that suit you, Judge Makhubele?
Yes.
Yes,
Thank you.
thank you.
Thank you for that.
We stand down.
Le- yeah,